gentlemen, this is Darryl Perry versus City of Keene, Fred Parcells and Gary Lafreniere, docket number 12, small claim 270A. This is scheduled for hearing on the motion, hearing on the merits. However, I have a motion to dismiss filed by the defendants.
Would you like to hear argument on that?
Yes,
Okay.
I want everything on the record.
Your Honor, Eric Moss, on behalf of the Keene defendants. With me at counsel table is Darryl Lafreniere, the Keene Fire Protection Officer, Prevention Officer.
Okay, just for one moment, is the record going to pick up these voices clearly from here? Good, thank you.
Also in the courtroom in the back in the gallery is Fred Parcells, the Keene Housing Inspector. In the first instance, Your Honor, the Keene defendants have filed a motion to dismiss, and we would ask this court to grant that motion and dismiss this claim without really getting to the merits at all. I would submit that the Keene defendant's motion to dismiss speaks for itself, but if you'd like to hear a specific argument on our facts, I'm happy to.
I'd like a record of this, please.
In the first instance, Mr. Perry fails to state a claim upon which relief might be granted. It is my understanding that Mr. Perry does not have an ownership interest in the property. Rather, he simply rents a room at 75 Leverett Street. The individual Keene defendants enter the property pursuant to a properly issued administrative warrant by Judge Burke, and the defendants enter the property solely for the purpose of inspecting the property for housing and code enforcement violations, to which they suspect and have probable cause to believe existed. The administrative warrant gave them no other authority. That's all they went into the house for. Plaintiff alleges he was awakened during the inspection. Plaintiff does not, however, provide any legal authority either in his original complaint or in his objection to our motion to dismiss for the proposition that his alleged injury constitutes a civil rights violation. And as such, we would ask that it be dismissed. Additionally, there is no suggestion that under Monell, a civil rights violation would exist against the City of Keene in any capacity under respondeat superior. Keene defendants are also entitled to qualified official and statutory immunity. Were this court to determine that a civil rights violation had been properly alleged, the individual Keene defendants are entitled to qualified immunity. A reasonable official in the Keene defendant's position would not have believed that conducting a property inspection pursuant to a properly issued administrative warrant constitutes a civil rights violation in any way, and therefore qualified immunity should attach.
What time did this inspection occur?
The administrative warrant was issued for a time frame between 8 a.m. and 6 p.m. only. The defendants went in at approximately 8:45 a.m., almost 9 a.m. They were in the house for less than 20 minutes. And in fact, in Mr. Perry's room itself for potentially less than 5 seconds. Just Mr. Lafreniere poked his head in just to take a look, make sure there's smoke detectors, check the walls and egress, and then left their room. So total in the house, maybe less than 20 minutes, and well within the time frame of the administrative warrant itself.
Judge,
I'll get to you. I'll get to you.
Likewise, we would ask that the court, again, if it were to find a civil rights violation issued, properly alleged, that official immunity similarly applies, that the Keene defendants are entitled to official immunity because their conduct was made within the scope of their official capacity. There's no argument about that here. They were acting as town officials when they entered the house to do the inspection. That their actions were discretionary and certainly not made in a wanton or reckless manner. And likewise, we would ask that statutory immunity similarly apply were this court to determine that a properly alleged claim was alleged. The alleged damages for being woken up fall squarely within the statutory meaning of personal injury under 507b5, and therefore the Keene defendants are entitled to statutory immunity under that statute.
Mr. Perry.
okay, I have filed an appeal or a response to their motion to dismiss.
And I have reviewed that.
The defendants appeal to their own authority, saying that as government officials, the government has granted them all of these immunities. Additionally, even though they did come in at 9 o'clock, I, at the time, was working a late second shift. I had been asleep for less than 2 hours when they came in, banging on doors, shouting, "Fire inspector, we're here for an inspection." Both Mr. Lafreniere and Mr. Parcells actually walked into my room while I was asleep, which is a violation of my privacy. Both Mr. Lafreniere and Mr. Parcells were given multiple chances to issue an apology for waking me. No apology was given. So basically, the defendants believed that their titles and their badges grant them immunity from personal responsibility, and that's what I want the court to decide.
Okay, sir, have you any authority that would indicate that at 9 o'clock in the morning, given an appropriately executed administrative warrant, violates your rights to privacy?
Well, I believe that the warrant was illegally issued by Judge Burke. I have a motion filed by my landlord that was filed to Judge Burke, citing political reasons that he believes that Judge Burke has vendetta against him. Can I issue those as?
What does that, if that was an issue raised by your landlord, how does that cover you in any respect, sir?
Well, because I am a tenant of my landlord, so if there's some kind of vendetta against him, I'm an innocent victim as
So you
a
believe
side
that
effect.
there's a trickle-down effect, if
Yes.
you will? Okay. Anything else, sir?
No.
Okay, I will take this motion to dismiss. Obviously, until I rule on the motion to dismiss, it would be premature to proceed on with the merits, so I'm going to rule on the motion to dismiss. And obviously, if I rule in Mr. Perry's favor, we will schedule the matter for merits. If I rule in the defendants, if I rule for the defendants and dismiss the case, then that will end the case here.
Your Honor, if I may.
Yes.
Unfortunately, given just the small claim nature of this case and the fact that unfortunately the key defendants have to potentially come back to argue a second time if the motion to dismiss were denied, we would simply ask for attorney's fees, given the fact that we believe that the claim is underlying frivolous on the fact that you've woken up, unfortunately, but due to a properly issued administrative warrant, and you've rather not take the time to have to argue.
Not requested attorney's fees in your pleadings?
Not in my motion, I have not.
Okay.
I would like to appeal his motion to request attorney's fees.
I don't think you want to appeal it until I rule. Okay, I'll take the matter under advisement.
Or I guess object would be the proper term.
Okay,
Thank you.
thank you.